Yeah, to be honest, Cian, I believe this amendment that we're putting forward is the most important amendment we're discussing today, precisely because it gives a blank cheque, carte blanche, to the Minister to make regulations under the emergency amendment of the Health Act that was passed earlier this year, which go way beyond, potentially, the specific scope of this bill. We would be happy to let this bill go through because we accept that it is necessary to have powers to prevent reckless behaviour in the context of licensed premises or places selling intoxicating liquor, because that is a real threat to public health. But we all accept, I think the government accepts, and everybody else accepts, these are draconian powers. They are not powers that under normal circumstances one would wish the state or the guards to have, because they are very serious draconian powers. So all of us have accepted this is an exceptional situation and have allowed power to be given to the state to do things that normally we, from a civil liberties point of view, we'd be very concerned about. We can accept that. This is exceptional. Those powers need to be available when they are clearly specified. What the offence is, what the penalty is. But this section means that the Minister for Health can prescribe as a criminal offence things that are not in this bill or that are not written down anywhere else so far. Now that is a power too far, and it is worrying. And, you know, ministers can make mistakes, they can make wrong moves, and there needs to be oversight of decisions that the minister may make in future which we might want to question in here. But we won't have the right to question. We won't have the right to challenge. The minister will have a blank cheque for things that are not to do with the stated intention of this bill or to anything that government is maybe even has considered at this moment. That is more than unusual, I put it to you, Ceann Comhairle, more than unusual. For that reason, we appeal to the government to take this section out. The bill, we would then be happy to let go through, but this section should come out because it is a blank cheque, and no government, no minister should be given a blank cheque about things that they could do in the future that we may not even have thought of or considered.
Deputy Minister.
Thank you. Firstly, maybe just to say, I think the intention of this particular section is maybe that the deputies have misunderstood the intention of this section. This section is essentially power that will prescribe the regulations that will apply to this particular bill. So as it currently stands, this doesn't allow myself as Minister for Justice or the Minister for Health to do anything new, or for the Minister for Health in particular to do anything new. Under the recently enacted Section 31A of the Health Act 1947, the Minister for Health already has an ability and is already able to make COVID regulations and can specify which one of those regulations have penal provisions, which ones of those don't, and then obviously it is an offence under this particular Act where somebody is in breach of that. That's already here, that's already in place. What this particular section simply does is it identifies the particular penal provisions that are relevant for this. So when this piece of legislation is potentially passed through the Houses, if it's approved, signed into legislation, the Minister for Health, having engaged with myself and any other relevant department, will identify, as we have already, the specific penal regulations that will be relevant to this bill, so that on Garda Síochána, when they walk into a premises, they know these are the exact regulations that we know need to be adhered to, and if they're not, then we can move to issue a direction to enforce either that a pub's closed immediately or that we take further steps at a later stage. If we were to remove this particular section from the bill, it would actually deem it unworkable, because you wouldn't actually be prescribing the particular penal regulations that are needed for Gardaí to enforce it. So it's probably, while the Deputy is saying it's the most important amendment, for me, if this was removed, the bill itself doesn't work. So for me, it's extremely important that Section 13 is kept in. It doesn't give any additional powers to the Minister for Health. They are already there. They're already very clearly enacted under, as I've mentioned earlier, Section 31A of the Health Act 1947. This simply links the two. Following the enactment of this bill, the Minister would then sign an order very clearly stating which of those provisions relate to this. But again, maybe to point to what I mentioned earlier, any new provisions that the Minister has to sign into law must come before the Houses. There's an opportunity for this House and the Seanad to annul those within 21 days of them being enacted, and that's a very clear provision there that deputies have. Thank you.
To respond to the Minister, you see, this is what connects this bill to the extraordinary powers that were given, which we supported, by the way, under the emergency legislation, which gives powers to the Minister for Health to prescribe certain events, activities as offences and penal offences. But the problem is here, and what's now changing, is that the enforcement powers that this bill provides for are now can be used for regulations made under that Act, which we don't know about in the future. Okay, so there's a whole range of new powers, enforcement powers, which then can be used in relation to other regulations, future regulations that the Minister may decide to bring forward. Now, that's a problem, to my mind. So while I accept there might be a need to connect one to the other, I think the consequence of this is that what everybody has said and accepted are draconian. Some of us think necessary in particular contexts can be applied to other contexts. Draconian powers can be applied to other enforcement powers. Draconian enforcement powers can be applied to other things, other actions, and that, I believe, is a problem and the reason we oppose this section.
Right in what he is saying, in that there are regulations, that the regulations are not specifically mentioned in this legislation because we're in very difficult and unusual times. Things are changing, new regulations are being made, but also there's a possibility, and as we hope things get better, that regulations can be removed, penal provisions can be removed, and if we were to have to put every single provision in this legislation, it would mean that at every stage we would have to go through this process and introduce legislation for that. So what this enables is me as Minister, working with Minister Donnelly, but other relevant ministers as well, to ensure that if there are any changes of regulations, that they will apply to this legislation without having to go through the legislative process. And that also applies not just where there might be new regulations, but where we're removing regulations that specifically apply to this, where we're removing penal provisions. Hopefully that will be the case for many of these into the future, hopefully sooner rather than later. But it's important to acknowledge that we're in a very unusual situation where things change, things are happening very quickly. We're trying to respond to a global health pandemic, and in doing so sometimes decisions have to be made quickly, and if we have to pass legislation every time that's the case, it obviously would preclude us from doing a lot. But again, I suppose just to point to the fact that if we remove Section 13 from the legislation, it essentially deems it not workable. Thank you.
Thank you.